Thank you for tuning into Bond Court. I want to continue posting Bond Court every night on YouTube, but the viewership and engagement on my channel has fallen off a cliff. I would greatly appreciate your help by hitting the like button and leaving a comment on my videos. Thank you and enjoy the show.
Mr. Thompson, you're charged with trespass on property after warning. I do find probable cause for that charge.
Your Honor, I apologize. Dominic Cunningham for the Office of the Public Defender. Just wanted to make sure my name was on the record.
Oh, I'm sorry. Yes, ma'am. Thank you for that. And State, you can go ahead and announce your presence as well for the record.
State of Florida, Trustee Tyner.
Okay,
Trustee Tyner for the State of Florida, my apologies.
that's okay. That's fine. Sir, I do find probable cause for that charge. And I also am appointing the public defender to represent you in this case. I'm ordering a bond of $100. Do you have any questions?
Your Honor, I apologize. I just wanted to stop him because he's talking about the facts of his case.
Mr. Thompson, I want to know if you have any questions about the fact that I set your bond on this case for $100. Since I did appoint the public defender, they do not want you talking about the facts of the case. They want you to just wait and discuss the facts of the case with the lawyer. Do you understand? Do you have any questions about the bond that I set for $100?
Your Honor, for the record, I just wanted to state that I do have competency concerns for this case.
Do you have anything you want to add about the bond that I set in this case?
Your Honor, we would be asking if the court would be willing to ROR. I just want to make sure we put on the record that he understands his case isn't closed. If the court.
Well, let's
is
just start
inclined
with
to
the
grant that.
request to ROR first. How about that?
Yes, Your Honor.
State, any objection?
His last conviction for trespass was on August 23rd. The state is gonna object. I mean, he's got a $100 bond. Given what's happening in the courtroom and the fact that there are concerns about whether or not he can understand the bond, and he doesn't have an ability to let us know if he can't afford that, I don't have an objection to ROR.
So the court is going to order that you be released as to this charge. You will have another court date. You will receive paperwork, and the paperwork will tell you when your next court date is. You have a lawyer. The lawyer we will need you to make an appointment to come to her office for an interview. It's important that you see the lawyer and that you come to court for your next court date. Do you understand what I just told you? Wait a minute, Madam Public Defender. One thing at a time,
I
please.
apologize, Your Honor.
Please. Do you understand what I just told you?
Okay, yeah, okay, that's fine, that's fine. I see everything on the paperwork here.
There's one other thing. As a condition of me releasing you today on this charge, I am ordering you to not return to where this happened. Do you understand that?
Your Honor, as the interpreter, I have to say that I'm not establishing effective communication with this defendant.
I understand. Thank you, Ms. Interpreter. For the record, put on the court minutes, the interpreter informed that she was not establishing effective communication with the defendant, and the public defender has competency concerns about the defendant. All right, well, we've done our best. Thank you, sir. You are excused. Is this the next stack or is the,
He doesn't have one yet.
I'm sorry, who's speaking?
I just asked whether this court date is on the paperwork.
Oh, thank you, ma'am. It will be included.
Your Honor,
Who's speaking?
Dominic Cunningham for the Office of the Public Defender. Just for the record, I just wanted to make it known, I did write a date on the paperwork that I gave him just so that he can go to our office and someone can speak to him there.
Thank you.
Does he have an arraignment date? Okay.
Go ahead and announce the arraignment date. Mr. All right, Mr. Thompson, please pay attention as we tell you when your next court date is. Madam Clerk?
Arraignment date is October 25th at 1 p.m.
All right, thank you, Mr. Thompson. You are now excused.
He does not understand the word, court date.
Thank you. The attorney case? Is it two attorneys? Okay. Brian Balick?
Which side, left or right?
This is the undone stack.
Good morning, Mr. Bailey. How are you?
You know what, put that up there, put it somewhere out of my way, so it's like, I'm getting confused. All right, we got a lot, don't we? All right, Mr. Balick, the court finds probable cause in your charge of aggravated assault. Counsel, would you announce your presence for the record?
Thank you. Good morning, Your Honor. Danielle Barbado on behalf of Mr. Balick.
And does counsel wish to be heard?
Yes, Judge, I'd ask that, I think the bond schedule for an ag assault without a firearm being specified is only $1,500. There is a unique situation where I think once the investigation is completed and the facts play out, this case will resolve rather quickly. Mr. Balick resides at this residence. All of the firearms and any ammunition have been removed from the residence. He is prepared to post a cash bond. I've spoken with his significant other who will be putting that bond up. I'm asking the court to follow the $1,500 bond schedule for a standard ag assault so that she can afford that along with her regular monthly expenses.
Well, the court had considered a significantly higher bond than that, I have to tell you.
I understand the facts are troubling and it does involve a firearm. However, upon arrest, we were immediately retained. We have worked with her to secure the residence in less than 24 hours. The firearms have been removed, ammunition has been removed. She anticipates posting a cash bond as opposed to using a surety bond and has informed me that funds are somewhat limited. He does not have any recent history. It's my understanding he has no convictions whatsoever, and he is not a flight risk. He has ties to the community. He will be living at the residence, living with his significant other, and we'd ask that the bond stay close to $1,500.
Well, what says the state? The court's troubled by reducing it, I can tell you that, but what says the state?
We did speak with defense, and they did inform us everything mentioned to the court just now. I would just leave it at your discretion, Your Honor. As long as it's within the bond schedule, he doesn't have a history. His prior arrest was for trespass, like 33 years ago. He has no convictions, and as she stated, he is going to be living at that residence, and the weapons have already been removed. So we would just ask for a no weapon and within the bond schedule.
All right, the court's job is to determine whether there's probable cause and what appropriate release conditions will be to protect the public, the community, the victim. The victim's not here. At least I don't see the victim here. The court's not setting a $1,500 bond, I can tell you that. The court finds probable cause and will set a bond of $3,500. The court is ordering no contact with the victim, not to return to the location where this incident occurred.
May I be heard on that condition, Your Honor?
You may.
That is his residence, and he does not have anywhere else to live. The alleged victim in this case is an employee of a landscape company that was servicing a neighboring yard. So we'd ask that he be allowed to return to his residence.
State?
I have no objection to him returning to his residence.
Well, can you confirm the facts that, I read 100 of these this morning, so, I can go back and read it for myself, or can you confirm the facts that, and I do remember a case involving a landscape
Yes, Your Honor. This
situation. Is this that case?
is
So,
that case.
okay.
And the victim does not live next door or anything of that nature. He was there working with a landscaping company.
Okay.
Given that, I have no objection to him being allowed to return to his
All right.
residence.
No contact with the victim, Madam Clerk, he can cancel that no return order. Further, you must surrender any firearms or weapons to law enforcement within 24 hours of release, and possess no firearms or weapons as a condition of release. Thank you.
Thank you very much. That's all I have before you. I'm going to call Danielle and give her all the details, okay? Bond you out, yes.
Marco Key. Is that the next attorney case? Okay.
Thank you so much.
Mr. Key, the court finds probable cause in your case for robbery, armed robbery with a firearm and wearing a mask. Counsel, state your presence for the record, and if you'd like to be heard, you may do so.
Good morning, Your Honor. David Haas making a limited appearance on behalf of Mr. Key. Would like to be heard about at least the issuance of a bond.
Go right ahead.
Your Honor, Mr. Key is 20 years old, I believe, with no prior criminal history. We certainly understand the allegations are serious. It does appear there's a co-defendant that is where the majority of the evidence comes from in the probable cause affidavit, so we would ask the court to consider that in fashioning a bond for Mr. Key.
What says the state?
Can you repeat that last part?
There's a co-defendant where the majority of the information linking allegedly Mr. Key to the robbery comes from, so we would ask the court to consider that and the state to consider that in fashioning a bond.
Based off the allegations and the affidavit, the state's just asking for the bond schedule that he not return, as well as not have any weapons or firearms and have no contact with the victim. We understand there's a co-defendant, but this affidavit is very detailed and does lay out how he came to be picked up by police.
All right, the court orders no bond. The court is ordering no contact with the victims, no return to the location where this incident occurred, possess no weapons, possess no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Now, shall I appoint the public defender to represent him, or are you representing him? Because I heard this phrase, limited appearance, and I don't really know what that means.
Your Honor, I've not been formally retained on the case. I was contacted last night and represented Mr. Key on another matter, so I would ask, at least for the time being, that the PD be appointed.
Did he fill out the paperwork? All right. Unfortunately, he has to fill out the paperwork. And if he didn't fill out the paperwork, then I cannot appoint the public defender. So he must believe that you're representing him.
We've had that talk this morning, Your Honor. He knows that I'm not in on the case just yet.
Well,
Your Honor, if he is not going to be appointed today, he can just fill out the AOI and send it to my office, and we can get that done.
well, I have a better idea. He'll fill out the paperwork now.
Yes, Your Honor.
Now, sir, listen to me carefully. The attorney said his appearance was limited. I just ordered no bond. You don't have an attorney. So if you want the public defender, you must fill that out. I don't want you to get lost in the cracks and rely on somebody else giving you that paperwork. If you don't want to fill it out, you do not have to. You can wait and see if you can do whatever it takes to retain the lawyer for full appearance. But from what he said today, he's representing you only for this initial appearance and nothing further. So if you want the public defender, you need to fill that out right now. And I will appoint the public defender if you qualify. And your public defender can withdraw from the case in the future if you retain a private lawyer to represent you. All right, any Spanish interpreter cases? Is that?
Thank you, Your Honor. I apologize for any confusion.
That's fine. Does he qualify? So, I mean, it's kind of funny, it took so long to fill this out, but yet it's blank. We need to know if you have an income, and we need to know if you have any children, so you need to fill that out.
Circle.
Go ahead, just fill it out. Just, sir, just fill it out. Sir, the public defender is appointed to represent you. All right, thank you, sir, you're excused. Dennis Sanchez.
Good afternoon. This is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good afternoon.
Good afternoon, Your Honor.
Mr. Dennis Sanchez, you're charged with DUI, driving under the influence. The court will order bond to stay at $500. Order that you not drive without a valid driver's license. The court is ordering that you consume no alcohol, and that you, as a condition of your bond, and that you undergo random alcohol monitoring, which will be conducted through the pretrial release program. The court is also appointing a public defender to represent you in this case. Thank you, sir.
Ok, muchas gracias. Ok.
Okay, thank you very much. Okay.
Here, sir. Sir, Your Honor, was that PTR with a bond or just a bond?
It's just a bond with alcohol monitoring.
Perfect, thank you.
Is the private attorney present? Okay. Did the private attorney indicate a desire to be present on the video? Oh,
Your
okay.
Honor, if I may,
Yes, ma'am.
I do believe the private attorney was here yesterday and it was reset for probable cause.
Oh, and I still don't have probable cause.
Your Honor,
This
I
is,
have a sworn affidavit
Oh, okay.
regarding this case.
Could you bring it?
Yes, permission to approach?
Yes, ma'am, you're granted. Thank you. All right, Madam Interpreter, this is Miguel Galarga. I'm mispronouncing his last name.
Galarza.
Galarza, okay, thank you. One moment.
Yes, Your Honor.
The court has reviewed the report from the officer. It is not sworn. It is a supplemental report. Has the defense had an opportunity to review it?
Your Honor, according to the email sent from law enforcement, it is sworn.
Okay,
I don't know if that's, I don't know how to verify that on the sheet, but I can read the email into.
no, ma'am. That's, as an officer of the court, I take it that the original is sworn to,
Thank you.
and that's fine. And what I was going to actually say is that I do have probable cause based upon this, and if the defense wanted a copy of the sworn, then I would just reset it again for tomorrow.
Okay.
But if the defense wants me to move forward, then I will find probable cause at this time and order a bond.
Your Honor, he has a private attorney, so I can't,
Well, you're standing right there beside him. I mean, why are you standing there if you?
I was coming up to
He
him.
has a private attorney. The court is appointing a public defender for the purpose of this hearing, since I do not have a private attorney present.
May I have an opportunity to review that?
Yes. Can you look at the one on her computer to just be sure it's sworn to?
Yes, Your Honor.
As an officer of the court, I believe you.
I
that it's
understand.
sworn to. But I just want her to look at it, just for her own benefit. The court does note that the original affidavit, it is sworn to.
Record, I did see that it was sworn on her computer.
Yeah.
Your Honor, while she reviews that, the state does wish to be heard on conditions of release.
Yes, ma'am.
Would you like for me to go ahead?
Let's just give the public defender an opportunity to finish reviewing the PC affidavit, incident report. Sorry.
Your Honor, I apologize because I wasn't present yesterday and I was told that he has a private attorney. I'm just reviewing.
Well, you know, that's all well and good, but I wasn't present yesterday either, and there's no private attorney present. So I'm appointing a public defender as I do on all cases unless there's a good reason not to. If the private attorney were here, or if I had a notice of appearance.
Yes, Your Honor, I was just apologizing for the time.
Oh, I do have a notice of appearance? Well, Ms. Public Defender, you are relieved of duty on this case. We do have a signed notice of appearance. So this gentleman is represented by counsel. Counsel has, for some reason, chosen not to be here today. Even if he was here some other day, he's not here today. The court does find probable cause. And state, you may be heard.
Yes, Your Honor. This case is, we are asking that he be held on no bond, given that the fentanyl amount is a punishable life offense. The defendant doesn't have a passport, but he is from Puerto Rico, and the risk of him returning there means that we would be asking that he be required to remain within Orange County on an electronic monitor or GPS monitor. If he is to be released, again, we're asking for no bond. And if there will be a bond set, we asked that it would be the maximum of the bond schedule. And that with the two charges combined would be, I believe, 1 million on the first count, or 1.5 million is, I believe what I was told yesterday. It's either $1 million or $1.5 million. Either way, we're asking for no bond, but if a bond is set, that's what we would be requesting.
So I am only aware of one count,
I see that now.
and I will grant your motion to set no bond. Bond will stay set at no bond.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Madam Clerk, that was the last Spanish case? Thank you, Ms. Interpreter. Have a wonderful remainder of your day.
Thank you, Your Honor. You do the same. See you tomorrow.
Tomorrow it is. Thank you.
Yes, ma'am.
Robert Crew? The court, oh, sorry. Mr. Crew, the court finds probable cause for the charge of trespass after a warning.
Your Honor, if I may.
You may.
The state of Florida has extended an offer to Mr. Crew of an adjudication of guilt, 7 days in the Orange County Jail, and no return to the offense. Would the court be willing to take that offer?
Yes, ma'am. How much time served does Mr. Crew have?
2 days, Your Honor.
Mr. Crew, is this your signature here at the bottom of this plea form? Did you read this plea form before you signed it?
Yes.
Are you under the influence of any alcohol or drugs or medicine today?
No.
Do you understand a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes.
There is sufficient factual basis in this case. You're alert, you're intelligent. I find probable cause for the offense. I am ordering 7 days in jail with credit for 2 days' time served. Honestly, I would have probably done just credit for time served or 5 days in jail, but I'm going to honor the state's offer in this case. Further, I'm going to order you to pay mandatory court costs. You have to pay the court costs within 180 days of your release from incarceration.
1 second. Your Honor, if I may.
Yes, ma'am.
Will the court be willing to reduce the court cost to a civil judgment?
Not at this time.
Thank you, Your Honor.
All right.
Were you saying that it would have been credit time served?
Well, I would have gladly given you credit for time served in this case, or less than 7 days in jail on this case.
Can I still do that, or?
Well, state,
It's the state's position that the 7 days was given because he was just convicted
Mhm.
trespass on August 29th of this year, which was barely a week and a half ago. So that's the reasoning for the 7 days, and we would ask that that be honored. That's our offer at this time.
well, let me just say this, state. It's not armed, it's not aggravated, it's bad, he needs to stop doing it, but it is what it is, and I would still do time served, but I don't want to undercut the state. Is the state gonna withdraw the offer if I do time served, or is the state gonna just,
We'll withdraw
respect
the
the judge's
offer.
position?
We will withdraw the offer, but my position was that the
No, no, no.
litigation-
So listen to what I'm saying. I'm gonna honor the state's offer if that's what the state wants. But if the state will decide to stand silent and let the judge do what the judge wants to do, I'll do time served. Which do
Understood.
you prefer?
We would prefer the 7 days.
Okay. The 7 days is going to stay because I'm respecting the state's position. Do you understand? So I would like to do 2 days in jail, but I also respect the state's position. That's how it works, sir. Sometimes we just have to respect the position of the other side, and I respect the state's position. So the sentence will remain at 7 days in jail with credit for 2 days' time served. But I also am informing the state that I generally don't like to see these long, lengthy sentences on a trespass case. This might be a different scenario because of what you just said, of him being convicted, what'd you say, a few days ago?
Yes, Your Honor, August 29th.
So, yeah, a couple weeks ago. So this is, I understand why the state wants the 7 days. All right. You are ordered to not return to the location where this incident occurred. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date.
And
Thank you, you're excused. That's it. I'm not sure. Did he plead no contest or guilty?
Contest, Your Honor.
Yes, he pled no contest. You know, there is a place on the top of the plea form to circle guilty or no contest.
I will do that, Your Honor.
All right. Roderick Stafford is, the court finds probable cause for trespass on property after a warning.
Your Honor, may I be heard as to release?
You may be heard as to release, yes, ma'am.
Your Honor, Mr. Stafford is currently going through competency proceedings in 2022 MM2141. For that reason, we'd be asking if the court would be willing to ROR on this case. The state would have offered Mr. Stafford an offer, but because he is currently going through competency,
What is the release status on the 22 MM2141 case?
Your Honor,
Bond, ROR, PTR? I just wasn't able to figure it out. Has the competency proceeding already begun? Has a motion been filed?
Your Honor, a motion has been filed. A notice of incompetency was filed, and I can tell you that date.
No, that's all. As an officer of the court, I believe you. State, I am inclined to do what the defense is requesting, considering the pending competency issues, if the state has no objection.
The state has no objection.
The court will grant that motion. The defendant is released on cognizance with the condition that the defendant is ordered to not return to the location where this incident occurred. No action will be taken on the out on bond case based upon the facts that have been presented to the court. Thank you, sir. Timothy Lafferty. Do you waive his appearance since I did find probable cause, or do you want me to reset him for tomorrow?
Your Honor, I'd like to reset him. He does have a pending offer from the
The
state.
court will reset for 24 hours. Defendant was not brought over due to behavior. Frederick Pinckney. The court finds probable cause for possession of paraphernalia. It is the court's intention to release on recognizance based upon the nature of the charge. However, the court does not mind hearing from the state. Is the state objects to that?
No objection. We had already anticipated that.
Okay. Court will release on recognizance as to this charge. Thank you.
Thank you, Your Honor.
Joe Brewer, the court, okay. Do you wish to, counsel, do you wish to waive his appearance?
Your Honor, I apologize. My laptop is,
So this is Joe Brewer, and had he been present, I would have ROR'd him. I would have, of course, wanted to hear from the state if they objected to that. And I would have taken no action on his out on bond case. So do you, state and defense, both of you can tell me your positions?
The state would have had no objection to the ROR.
Do you want to waive his appearance, or do you want me to reset him?
we can waive his appearance, Your Honor.
All right, the court does find probable cause. The court notes that the defendant is not present due to medical, but the court is ordering ROR once his medical is cleared. And the court is further ordering that the defendant have not returned to the location where this incident occurred. The court is taking no action on the out on bond case. Madam Prosecutor, did you have something else?
It was medical, correct? Thank you. No, we have everything we need.
Your Honor, I apologize. May I have just 1 second? I need to restart my computer.
Okay, Una Davis? Is that who you are?
Your Honor, we have one more on the move up. It should be Washington.
Washington, Madam Clerk? Give me that step back. Jalen Washington. So, Mr. Washington. You have two cases, both are failure to appear. Bond will stay set at no bond on both counts of the 2020 CF 9717 case. Bond will stay set at $1,000 on the 2020 MM 7702 AO case. And the court does appoint the public defender. Thank you.
Just for today.
Kayuna Khadijah Davis? Yes, ma'am. All right, ma'am. You were picked up for violation of your probation. Condition 4, based on a new arrest for trespassing. And condition 8, failing to pay costs of supervision. And a special condition, failing to enroll in the batterers intervention program. Bond will stay set at $5,000. Thank you, ma'am. Robert Roberson. Sir, you were picked up for violation of your probation, and bond will stay set at no bond. The following conditions are alleged new law violations of battery, domestic violence, and tampering with the witness. Also, special condition, consuming illegal drugs and testing positive. Also, a special condition of failing to pay cost of supervision. Bond will stay at no bond. Anthony Waller. Mr. Waller, you were picked up for a violation of your parole. Conditions as follows. Condition 8, failing to pay costs of supervision. Condition 7, failing to keep appointments scheduled in July and August of 2022. Special condition, failing to complete an anger management class. And special condition, failing to complete community service hours. Bond will stay set at no bond. Isaiah Saita.
Yes, ma'am.
The court finds probable cause for count 1, aggravated battery on a person 65 years or older and causing great bodily harm. Bond is set at $5,000. Count 2, resisting an officer with violence. Bond is set at $1,000. Count 3, battery on a law enforcement officer. Bond is set at $150. The court is ordering that you have no contact with the victim, that you not return to the location where this incident occurred, that you possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release.
Your Honor, may I be heard as to the bond amount?
Yes, ma'am.
Your Honor, the defense would ask the court to consider lowering the bond based off of the affidavit. There are some clear mental health issues here. Additionally, we would ask for ROR on count 3 because it would be double jeopardy for him to be convicted of both the resisting with violence and battery on a law enforcement officer because this was one incident.
The court's going to deny the motion as to lowering the bond. The court also is denying the motion as to double jeopardy since this is not a trial and the defendant is not going to be convicted of anything. The court is simply finding whether or not there is probable cause.
Yes, Your Honor.
Gary Verdier. The court finds probable cause for kidnapping or false imprisonment, and bond will stay set at $3,000. The court finds probable cause for battery, and bond is set at $500. The court is ordering that you have no contact with the victim, not return to the location where this incident occurred. Actually, you qualify for the court had intended to order pretrial release in this case. Based upon the fact that you do qualify, I am ordering pretrial release. Cancel the order regarding a bond. The defendant qualifies for pretrial release. So you are required to comply with the conditions of pretrial release, as well as have no contact with the victim, as well as surrender any firearms or weapons in your possession to law enforcement within 24 hours of release, and possess no firearms or weapons as a condition of release, and not return to the location where this incident occurred. Thank you.
Sir.
Dennis Young.
There is a victim?
All right, as to Mr. Young, there is a victim. The court does find probable cause for the charge of aggravated battery, domestic violence, and the victim will raise your right hand to be sworn in.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Kayshell Hayes.
And I need you to speak into the microphone so I can hear you. What's your last name again?
Hayes.
Thank you, Ms. Hayes.
Good morning. What's your relationship with the defendant?
That's my boyfriend.
Are you seeking contact with him today?
No.
Do you two live together?
Yes.
And are you afraid of him?
No.
Okay. Has anything like this ever happened in the past?
No.
No further questions from the state at this time.
All right, defense.
Ma'am, will you be residing in the home or would you be moving?
No, we live together.
But you do not want contact with him?
I do.
You do want contact with him?
Yes.
All right, so you told the state that you were not seeking contact with him, and now you're telling the defense attorney that you do want contact with him. So let's be sure you have complete understanding of what's being asked, okay?
I understand. I thought she meant, have we been talking today?
Okay, so you do want contact with him.
Yes, ma'am.
So you do want him to be able to come back to the place where you reside.
Yes, ma'am.
Okay, I think we're clear on that now. Thank you all. All right, the court will order a bond of $3,500. Does he qualify for a pretrial release?
The charge, Your Honor.
Okay. And order no hostile contact with the victim. Possess no weapons, possess no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release.
Sir.
Yvonne Duran. Mr. Duran, Duran? Yes, Duran. All right, Ms. Duran. The court finds probable cause in your case for battery domestic violence, and I order you to be released on the pretrial release program. You do not qualify for the public defender, so I am not appointing a public defender. You do have the right to a lawyer, so you can try to retain your own private counsel to represent you. You must comply with the conditions of pretrial release. In addition, the court is ordering that you possess no firearms or no weapons and surrender any firearms or weapons to law enforcement within 24 hours of release. And the court is ordering that you not return to the location where this incident occurred. with the exception of a one-time visit in the presence of law enforcement to recover personal belongings, and that you have no contact with the victim. Thank you. Zekaria Fennel. The court finds probable cause for battery, domestic violence, and I am ordering you to be released on the pretrial release program. You are required to comply with the conditions of pretrial release. In addition, the court is ordering that you have no contact with the victim, that you possess no firearms and no weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release, and that you not return to the location where this incident occurred with the exception of a one-time visit with law enforcement to recover any personal belongings. Thank you. Michael Garcia. Michael Garcia? All right. Mr. Garcia, the court finds probable cause for battery, domestic violence, and bond is set at $500. The court is ordering no contact with the victim, and that you possess no firearms or weapons and surrender any firearms or weapons in your possession to law enforcement within 24 hours of release, and that you not return to the location where the incident occurred with the exception of a one-time visit in the presence of law enforcement to recover personal belongings. Kenny Mason. 500. Kenny Mason. All right, Mr. Mason. The court is ordering as follows. The court finds probable cause for the charge of battery, domestic violence, ordering no contact with the victim, that you not return to the location where this incident occurred, that you maintain a separate residence from the victim, that you possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release.
Your Honor, can we have a one-time return with law enforcement if necessary?
Yes, the court will allow a one-time return in the presence of law enforcement to recover any personal belongings or effects.
Your Honor, what was the bond amount?
500.
Here you go.
Ryan Parsons. Mr. Parsons, the court finds probable cause in your case for battery, domestic violence. You do qualify for the pretrial release program for which the court will order you to be released.
Your Honor, it looks like there is a victim.
Oh, ma'am, raise your right hand to be sworn in.
Do you swear to tell the whole truth? I'm sorry, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name for the record.
my name is Dawn M. Evans.
All right, Ms. Evans, we do need you to speak into the microphone, and lawyers may have questions of you.
Okay.
Good morning.
Mm-hmm.
What's your relationship with the defendant?
He's my boyfriend.
And are you seeking to have contact with him moving forward today?
Yes.
Are you afraid of him?
No.
Has anything like this ever happened in the
Never.
past? And do you two live together?
We do.
Are you asking that he return to the residence?
Yes, absolutely.
No further questions at this time, Your Honor.
Any questions, defense?
No, Your Honor.
The court is releasing you to the pretrial release program and ordering you to comply with all terms of pretrial release. Further, the court is ordering you to have no hostile contact with the victim, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, sir. Debbie Rampasad.
Yes, ma'am.
The court finds probable cause in your case for battery, domestic violence, and I am ordering you to be released in the pretrial release program, ordering you to have no contact with the victim, and ordering you to not return to the location where this incident occurred with the exception of a one-time visit in the presence of law enforcement, and ordering that you possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, ma'am. Jacinia Valencia. The court finds probable cause in your case for battery, domestic violence, and I am ordering that you be released on the pretrial release program. You must comply with all terms of pretrial release. Further, you must have no contact with the victim, not return to the location where this incident occurred with the exception of a one-time visit with law enforcement to retrieve personal belongings. You must possess no weapons and no firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. Thank you, ma'am. Rakia Abdul Rahman. The court finds probable cause for burglary of a conveyance and sets bond at $1,500. The court finds probable cause of petty theft and sets bond at $150. Further, the court is ordering that you have no contact with the victim and not return to the location where this incident occurred. Thank you.
1 second.
Your Honor, Angel Acevedo bonded.
Okay, per the jail staff, Angel Acevedo bonded. Douglas Allen. Sir, you were picked up for an outstanding warrant for burglary of a structure where bond will stay at $2,500 and criminal mischief where bond will stay at $500. Hold on one moment. It's conditions of release are that you have no contact with the victim, co-defendants, or witnesses, and not return to the location where this incident occurred. Thank you. Haley Horvath. Haley.
No, Your Honor, I believe we skipped one.
Oh, who do you think we skipped?
Mr. Fry?
Mohammed Farhi? All right, Mr. Mohammed Farhi. I don't have,
May the defense be heard on probable cause.
well, I don't have paperwork on Farhi. I might have attached it to something and handed it to the clerk. Can you see if I mistakenly gave it to you? Oh, no, it's out of order. Here it is. It's, so you are Mohammed Farhi? All right, sir. The court does find probable cause in your case,
Your Honor,
but I will hear from defense. You wanted to have a motion regarding the probable cause?
yes, Your Honor.
Yes, go ahead.
I believe he's charged with trafficking marijuana more than 25 pounds.
Yes, ma'am.
The defense takes the position there's no probable cause.
It's more than 25 pounds or 300 plants.
Yes, Your Honor.
Okay.
The defense still takes the position that there's no probable cause.
Yes,
The only
ma'am.
thing the affidavit states is that there was bulk marijuana.
Mm-hmm.
That marijuana was not tested, it was not weighed. The statute requires it to be over 25 pounds
Mm-hmm.
or to be 300 plants or more. We have none of that information.
All right, let me just relook at this then, because I found probable cause. Let me see. And state, you can be heard as well. Or maybe I got something wrong, because defense said it doesn't have a weight. State, I think defense, looking here, re-looking at the affidavit again, defense seems to be correct. Does the state have any objection to the motion, or does the state wish the court to allow the state 24 hours to supplement the probable cause?
The state would be asking for 24 hours to supplement probable cause.
All right, at this time, the court is granting the state's motion and allowing the state 24 hours to supplement the probable cause. The case will be reset for in the morning. Thank you. Haley Horvath. And I think there might have been two cases for Haley Horvath, and they were out of order. Did the clerk put them back in order for me? Or is that it? Okay. Okay, there are two cases, unless it was two different Haley Horvaths. Okay. Haley Horvath, ma'am, the court finds probable cause for home invasion, robbery with a firearm, bond will stay set at no bond. Kidnapping with the firearm, bond stays at no bond. Carjacking with a firearm, bond stays at no bond. Grand theft, second degree, bond is set at 150. And carrying a concealed firearm, bond is set at 2,500. The conditions of this particular case are that you have no contact with the victims, that you not return to the location where this incident occurred, that you possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of your release. Further, you have a second case of carrying a concealed firearm, bond will stay set at 2,500. And the court is ordering that you possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release as to that charge. You have a third case of, that you're out on bond or there's a release. I'm not sure what the bond is, and Madam Clerk, I may not need to know it. But it's 2022 CF 8906 AO. If both counts were charged, I am revoking bond as to both counts and ordering no bond. But if both counts were not charged, Madam Clerk, can you tell me? Both counts? The court is setting no bond as to both count 1 and count 2. We're revoking the original bond. Cedric Jackson. Mr. Jackson, the court finds probable cause for possession of cocaine and sets a bond of 1,000, I can't read my own handwriting. 2,000. Madam Clerk. I checked right through the. Is it 2, 1, or 4?
That's one.
Okay, sorry. My mistake. $1,000, and the court sets a bond of $150, sorry, sir, as to the possession of paraphernalia. The court is taking no action on the out on bond matter. Thank you, sir. Robert Jackson, sir. The court finds probable cause in your charge of aggravated assault with a firearm, and the court does set a bond in this case of $3,500. The court further finds probable cause on count 2 and sets a bond of $150 for resisting an officer. You are ordered to have no contact with the victim, not return to the location where this incident occurred, surrender any weapons or firearms to law enforcement within 24 hours of release, and not possess any firearms or weapons as a condition of your release. Thank you, sir. Al Pacino.
Al Pacino Jr.
Oh, okay. Al Pacino June. Al Pacino. Al Pacino?
Al Pacino.
Okay, sorry. You are charged with failing to appear, for which bond will stay set at no bond on both counts of your failure to appear. Thank you, Mr. June. Al Pacino. Joshua Lozana Batista? Mr. Batista? Sir, you were picked up for failure to appear in court for 2 counts. Bond will stay set at no bond on both counts. Thank you, sir. Angel, I am not going to even try it with this last name. Angel Gabrielle.
Pacheco.
Oh, did you say Pacheco?
Yeah.
Oh, okay, well, we just misspelled it. Somebody put PS, and it's actually PA? Oh, okay, so we just misspelled it.
Your Honor, have you heard as to probable cause?
Yes, ma'am, you may.
Your Honor, the defense takes the position that there's no probable cause on this case. The marijuana was not weighed. I also do not believe it was tested, so we don't know if it's over 20 grams or not. So we'd say that there is no probable cause as to count 1 or 2.
Well, as to count 1 is, you're right, both count 1 and count 2 address the cannabis. Count 3 addresses the tetrahydrocannabinols. What says the state as to the defense motion in count 1 and count 2?
The state would be asking for 24 hours to establish the weight and presumptive positive results.
All right.
Your Honor, may I have one moment? I apologize.
Yes, ma'am.
Your Honor?
Yes, ma'am.
It does appear that Mr. Pacheco does qualify for pretrial release. So if If the court is inclined to release him on pretrial release after a discussion with him, the defense would withdraw their motion.
The court is inclined to release him on pretrial release.
Your Honor, we would withdraw our motion.
So
at
the
this
court does find probable cause as to possession of cannabis. Well, is this correct, though, pretrial release? Because possession of cannabis, count one, is with the weapon, but, so this is correct?
Yes.
All right, yes, then I am finding probable cause, and I am releasing you on the pretrial release program. I would find probable cause as to count two as well, possession of cannabis greater than 20 grams, and count three, possession of tetrahydrocannabinols. You are released on the pretrial release program. You must comply with all conditions of the pretrial release program, and the court is further ordering you to possess no firearms or weapons and surrender any firearms or weapons to law enforcement within 24 hours of your release. Do you have any questions about that? All right, thank you. DeMarcus Reddick. Mr. Reddick, the court you were picked up for failure to appear, and bond will stay set at no bond on all three counts for your failure to appear. Thank you, sir. Tershawn Rimbert. Mr. Rimbert, the court finds probable cause for burglary of a structure. Bond stays at $3,500. Count two, resisting an officer. Bond stays at $500. Count three, possession of burglary tools. Bond is set at $100. Sir, the court is ordering that as a condition of bond, that you have no contact with the victim, that you not return to the location where this incident occurred, that you possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release.
Hold on one second.
Hold on one moment. He has an out on bond case, and I have a notation here to revoke that, but let me just see why.
Your Honor, may I be heard?
On the out on bond?
Yes, Your Honor.
Yes, ma'am, go ahead.
Your Honor, this case, he was arrested on July 1st, and there's been no action since that time.
No.
And for that reason, we'd ask for no action to be taken on this case.
So, what do you mean there's no action? He has a bond, so.
He's out on bond, but there's been no information filed in this.
Oh, okay. Is that confirmed by the state? No information's been filed?
I'll check, but I trust
Okay.
Miss Madam Public Defender. Just one moment.
No, why did I say revoke on this?
That's the possession of the controlled substance.
Yes, ma'am.
Yeah, I'll go ahead and grant that and take no action. I don't know why I wrote to revoke that, because normally I wouldn't have revoked that particular bond. So I reread it, and I don't see any reason why I would do that, so I'm going to grant the motion.
Additionally, defense was correct. We're
Okay.
waiting on FDLE.
All right, thank you. All right, this is, we ready for this? Christopher Santos. The court finds probable cause for possession of ammunition by a convicted felon, and bond will stay set at $4,000. Condition of release, you're ordered to possess no firearms or weapons or ammunition and surrender any to law enforcement within 24 hours of your release.
Yes, ma'am.
Joshua Streeter. Bonded per the jail staff. Robert Sweet. Sir, the court finds probable cause in your case of robbery with the firearm, and bond will stay set at no bond.
Your Honor,
Albert,
are there any additional conditions for that?
bond is set at no bond. Albert Valdez.
You don't qualify.
The court finds probable cause for possession of methamphetamine. Bond stays set at $1,000. Nathan Walker, the court finds probable cause for possession of methamphetamine. Bond, Mr. Walker, you qualify for a pretrial release. The court's ordering you to be released pretrial release. You're ordered to comply with all the terms of the pretrial release program. Jahadra Ward,
1 minute, Your Honor, she's approaching.
I'm sorry. Did you want to do with no alcohol or drugs?
I'm sorry, I didn't hear you.
For the condition for Walker, did you want to put no alcohol or drugs for a condition?
Yes,
Okay, thank you, Judge.
yes. Jahadra Ward. You were picked up for failure to appear. Bond will stay set at no bond on your failure to appear case. Jacqueline Nicole Karlowicz,
She bonded, Your Honor.
previously bonded per jail staff. John Schnelling,
She's approaching, Your Honor.
Mr. Snelling, the court finds probable cause for DUI, and the court finds probable cause for driving on a suspended license with knowledge. I'm ordering you to be released in the pretrial release program. Condition of release are that you possess and consume no alcohol or illegal substances and comply with all other terms of pretrial release. Kenneth Jean.
She refused, Your Honor.
This is a trespass case for which the court does find probable cause. The court had intended to set a bond on this case, a reduced bond of $150. Do you want me to find probable cause, or you want me to reset him for tomorrow?
Your Honor, we'd like to reset him. He does have an offer.
All right, reset for tomorrow due to an offer. The defendant refused to be here today. Tremont Jones. Tremont Jones, the court finds probable cause in your case for trespass.
Your Honor, if I may?
You may.
The state has extended an offer of an adjudication of guilt and credit for time served, no return in court costs. Would the court be willing to take that offer at this time?
Yes, ma'am. What's the credit for time served?
1 moment, Judge. 1 day.
All right. Counsel, you need to tell me if he's entering a plea of guilty or no contest.
Your Honor, I apologize. That's going to be a no contest, please.
All right. Mr. Jones, is this your signature here at the bottom of this plea form? Did you read the plea form before you signed it?
Yes.
Are you under the influence of any alcohol or drugs or medicine at this time?
No.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes.
There is a sufficient factual basis to accept your plea. You're alert, you're intelligent. I'll adjudicate you guilty. Order 1 day in jail with credit for 1 day time served, and order you to pay mandatory court costs, which must be paid within 180 days if you're released from incarceration. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Any questions? All right, thank you. You may exit. Janine Scaglione. Ms. Scaglione, the court finds probable cause for your charge of trespass on property at the warning.
Your Honor, if I may?
You may.
The state has extended an offer of an adjudication of guilt, 7 days in the Orange County Jail, and no return to the scene with court cost. Would the court be willing to take that at this time?
Yes, the court is willing to consider that. State, why do you want 7 days in jail on this case? Well, how much time does she have, 7 days? All right, so why 7 days instead of the credit for time served?
Her last conviction was at the beginning of the month for burglary of a conveyance, and she has an extensive trespass history. No.
All right, I'll accept that. The court, sorry, what was it, guilty or no contest? I'm
No
sorry.
contest. I did remember to circle that.
All right. Ms. Scaglione, is this your signature here?
Yes, ma'am.
Did you read this plea form before you signed it?
Yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine this afternoon?
No, ma'am.
You understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
I suppose, yes, sir, ma'am.
You understand that?
Yes, ma'am.
All right, there is a sufficient factual basis. You are alert, you are intelligent. I'll adjudicate you guilty, order 7 days in jail. You will be given credit for the 2 days that you have already served. Further, I am ordering you to not return to the location where this incident occurred and that you pay mandatory court costs within 180 days of your release. Thank you, ma'am.
Thank you.
All right, one last thing, sorry, ma'am. One last thing, sorry. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Now you may be released. Vincent Strouder,
Behavior, Your Honor.
do you want me to reset him for tomorrow or waive his appearance?
Can we reset him, please, Your
All
Honor?
right, due to behavior, defendant did not come. It'll be reset for 24 hours. To Daria Connolly. The court, you were picked up on an out-of-county warrant from Volusia County. Bond will stay set at $250. Yes, ma'am, that's it. Richard Coop Ryder. Mr. Coop Ryder. Is it Cooper Ryder or Coop Ryder? Coop Ryder. Mr. Coop Ryder? Are you Mr. Coop Ryder?
Yes, ma'am, I am.
Okay. You were picked up on an out-of-county warrant from Hillsborough County for which bond will stay set at no bond on both count 1 and count 2.
Yes, ma'am.
Thank you, sir. Lamar Linhart. Mr. Linhart. Am I going too fast? Mr. Linhart, sir, you were picked up on an out-of-county warrant from St. John's for which bond will, for failure to appear, for which bond will stay set at $4,000. Thank you, sir. Brian Saunders, you were picked up on an out-of-county warrant from Seminole County for failure to appear, for which bond will stay set at no bond on both count 1 and count 2 for failure to appear. Thank you, sir. Luis Villanueva.
He's approaching, Your Honor.
Am I going too fast?
Oh, they get to have.
Mr. Villanueva, sir, you were picked up on an out-of-county warrant from Osceola, Florida. Bond will stay set at $1,000 as to that out-of-county warrant. Thank you. I'll try to slow down. Brian Cruz.
Approaching, Your Honor.
Mr. Cruz? Mr. Cruz, you were picked up for violating your probation, condition A, by failing to report to the probation office as directed. Bond will stay set at no bond as to that violation. Thank you, sir. Elijah Dixon, I need the paperwork for the new law violation, on Elijah Dixon. That's all you have? Ms. Prosecutor?
Yes.
I don't have anything to substantiate the officer's words that there was a violation of probation in the officer's presence. Do you want 24 hours to provide me with that?
Yes, Your Honor.
All right.
Yeah.
All right, the court will reset this case for in the morning tomorrow, give the state 24 hours to provide supplemental information as to the new law on view violation of probation. Cloudy Durrell. Sir, the court finds you were picked up for violation of your probation for the special condition of failing to successfully complete 50 hours of community service, and condition A, failing to report to the probation officer as directed for July 2022, for which a bond will remain set at no bond. Ralph Hodge. Sir, you were picked up for violation of your probation. The following conditions. Condition N, by failing to live without violating any law, to wit, testing positive for cocaine on or about 8/17/2022, and violation of a special condition by failing to successfully complete or remain in drug and alcohol treatment until determined to be released by the provider. Bond will stay set at no bond on both allegations of violation of probation. Thank you. Alan Bradford Pullen.
Your Honor, Alan Pulley refused, or Pullen.
Your Honor, we would waive his appearance.
The court notes the defendant was picked up for violation of probation, for which bond will stay set at no bond. Defense has waived his appearance. On the new law violation, bond will stay set at no bond on both count 1 and count 2. Sorry, the court will set a bond on count 2 of $1,000, no bond on count 1. Actually, at the risk of seeming wishy-washy, the court is actually going to leave bond at no bond on count 2. Sorry. Brian Quigley,
Yes, ma'am.
you were picked up for violation of your probation. Special condition, failing to undergo a drug or alcohol evaluation. And special condition, possessing or consuming illegal drugs, to wit, cocaine and marijuana, as evidenced by a urine sample on or about August 10th, 2022. Bond will stay set at no bond.
Your Honor, may I have 2 minutes? I wasn't able to go over the city ordinances that have pleas, but they're all in the back right now.
Yes, Your Honor.
Okay, we're back on the record. Chelsea Ann Augusta Garcia,
Bonded, Your Honor.
previously bonded per jail staff. Dondre Allen Byrd.
Yes, ma'am.
Sir, the court finds probable cause for possession of alcoholic beverages or open containers.
Your Honor,
Yes, ma'am.
the state did extend an offer of an adjudication of guilt and credit for time served. Would you be willing to take that at this time?
Yes, ma'am.
You sign there. And it's going to be a no contest plea.
Thank you, ma'am.
May I approach?
Yes, ma'am. How much time, sir? Mr. Byrd, is this your signature at the bottom of this plea form?
Yes, ma'am.
Did you read this plea form in its entirety before you signed it? Are you under the influence of any alcohol or drugs or medicine today?
No, ma'am.
Do you understand that a conviction on this case will subject you to deportation if you're not a U.S. citizen? There is a sufficient factual basis to accept your plea. You are alert, you are intelligent, I'll adjudicate you guilty and order 2 days in jail with credit for 2 days' time served. Further, I will order that you pay mandatory court costs to the clerk of courts within 180 days of your release. I am ordering your release as to this charge. Do you have any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you. Joseph Diaz Acevedo.
Yes.
Are you Joseph Diaz Acevedo?
Yes.
In your case, the court finds probable cause for possession of alcoholic beverages or open containers.
Your Honor,
Ma'am?
the state has extended an offer of an adjudication of guilt, credit for time served, and court costs. Would the court accept a
Yes,
no
ma'am.
contest plea to
How much
that?
time served? Yes, ma'am. How does the defendant wish to enter his plea to accept this charge?
No contest, Your Honor.
Mr. Diaz Acevedo, is this your signature here?
Yes.
Did you read this plea form before you signed it?
No.
Yes or no?
No.
Here.
Your Honor,
Yes,
I
ma'am.
did go over that plea form with him in the back. It's the form.
All right. Did you go over it completely with him
Yes,
in the
ma'am.
back? All right, so you explained to him all of these rights, 1 through 12, and then you explained to him 13 through 20, every single thing on here?
Yes, Your Honor, and I believe he would testify that he understood what I said.
All right. Did you have any trouble understanding what your attorney went over with you regarding this plea form and the rights you're giving up?
Well, she explained that I'll be let go today and that they'll charge me court costs and I'll have to pay.
Okay, did she explain to you that you're giving up the rights on this plea form by entering a plea of no contest?
I don't understand.
Your Honor, I'll go over it with him again.
Okay.
I'll be able to leave, right? I just have to pay a fine.
Your Honor, would the court be willing to ROR this? It seems that he doesn't understand the rights that he's giving up.
Any objection?
State. No objection, sorry.
What order you released on recognizance? Condition of release, not to return to the location where this incident occurred. Thank you. Christopher Nahart. Christopher Nahart? All right, in your case, the court finds probable cause for disorderly conduct. Is there an offer on this case?
There is, Your Honor, we just need a pen for him to be able to sign.
Okay. And so does he wish to accept the offer?
Yes, Your Honor, it's an adjudication of guilt, credit for time served, and court costs, and he'll be pleading no contest.
All right,
He has 2 days in, Your Honor.
2 days, okay, thank you. Mr. Nahart, is this your signature here at the bottom of this plea form? And did you read this plea form in its entirety before you signed it? Did you read the plea form before you signed it, sir? Yes. Do you understand that you're giving up all the rights on the plea form by entering your plea of no contest? Are you under the influence of any alcohol, drugs, or medicine? No. Do you understand a conviction on the case will subject you to deportation if you're not a U.S. citizen? Yes, ma'am. All right, there's a sufficient factual basis. You're alert, you're intelligent. I'll adjudicate you guilty, order 2 days in jail with credit for 2 days' time served, and order you to pay mandatory court costs within 180 days of your release. I am releasing you as to this charge. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Any questions? No, ma'am. Thank you, sir.
And Your Honor, he is also out on bond for the possession of cocaine.
Oh, no action on the out on bond case. No action on that case. Thank you. Samantha Salazar,
Bonded, Your Honor.
previously bonded per jail staff. Chauncey Taylor,
Bonded, Your Honor.
previously bonded per jail staff. I don't have any more papers. You have any more people? Nope. No more people, no more papers means no more cases. Recess.
For the state of Florida. No problem.
The first case, George Louis Adames, the court does not have probable cause paperwork in that case. And so I'm gonna go ahead, sorry, I'm gonna go ahead on and request that paperwork. I'm sorry, there's a lot of noise. I can't hear myself. So I'm going to go ahead on and request that paperwork before the court is able to find probable cause. State, are you able to provide that to the court tomorrow?
Your Honor, all I have is that it was a warrant. I don't have I don't have the warrant or the accompanying paperwork.
All right, nor do I.
Your Honor, Officer Osborne from PTR advised that if she is given a couple of minutes, she can send that information to the court.
If she can do that, that's fine. We'll just pass the case and move on to the next one.
Your Honor, Officer Osborne would need to be present to discuss PTR on each individual case. Would you give her a couple of minutes to send over the warrant?
No, we're going to move on and we'll just, we'll do that at the end.
Okay, thank you. Have a seat, sir. We'll call your case again.
Devin Bartlett.
Mr. Bartlett is present and approaching, and Your Honor, may defense be heard regarding probable cause?
Yes, ma'am.
Your Honor, regarding probable cause, defense would argue that flight alone is not enough. According to the four corners of the police report, Mr. Bartlett was only speaking to others at the back of the market when law enforcement arrived and was told to drop and lay on the ground. However, at that moment, there was no lawful arrest being done. In addition, the alleged substance in the case, in the police report, which seems to have been allegedly cocaine, was not tested. And also, defense would argue that the knife referred to by the police in the four corners of the police report, which was a 5-inch knife, would not fall under the weapon definition of a concealed weapon. There is case law that states that if it's 4 inches and doesn't have the characteristics of a weapon itself, it does not fall under the concealed weapon restriction, and therefore a permit is not required. Therefore, defense is objecting to probable cause on Mr. Bartlett's case.
State.
The department was sent to this location based on a call for narcotics sales. So at the time they arrived, they already had probable cause to detain the individuals. And as for the weapon being considered a concealed weapon, I have no objection to that argument.
What about the testing of the controlled substance? I think that's the cocaine alleged in count 1, that it wasn't tested. And I don't see where there's any presumptive field test in the PC affidavit.
If the dog alerting to the presence of narcotics is not enough, we would be asking for a 24-hour reset to establish probable cause for that charge.
Okay.
May defense be heard regarding that?
Just very briefly.
Sorry?
Yes, briefly.
Okay, according to the police report, the canines were actually passed around the vehicle. The presumptive substance found on Mr. Bartlett would be on his person. The canines were nowhere near his person.
All right. The court is ready to rule. As to count 1, possession of a controlled substance without a prescription being cocaine, the court grants the defense motion and finds there's no probable cause for that. The defendant is released on recognizance as to count 1, or that count. As to the possession of drug paraphernalia, the court finds probable cause and bond is set at $500. As to resisting an officer without violence, the court finds there's no probable cause and releases the defendant on his recognizance. As to the concealed weapon, the court finds a probable cause and sets bond at $500.
Your Honor, also Officer Osborne advised that he does qualify for direct PTR.
Rather than set bond, the court would order PTR. I'm sorry, was that last name Osborne?
Yes, Your Honor.
All right, so just, Officer Osborne just confirmed what the public defender said for me, and I am going to order direct PTR. All right, rather than set bond, the court is ordering the defendant be released PTR on the counts where the court found probable cause and released RR on the other 2 counts.
So, Your Honor, just to clarify, he'll be on PTR on the possession of drug paraphernalia and the concealed weapon. It counts ROR.
Yes, ma'am.
Okay, thank you, Your Honor.
Thank you. Christy Blankenship.
Ms. Blankenship waived her appearance. We can proceed without her.
All right, and just that reminds me, I am appointing the public defender on all cases unless otherwise noted. The court notes that Ms. Blankenship was picked up for violation of probation or community control. Bond will stay set at no bond as to that case. Yes, Yasso Cabrera.
President approach.
So you were picked up for failure to appear on a written promise to appear. Bond will stay set at $500.
Thank you, Your Honor.
Thank you. Thank you, sir. Alvin Hasley.
Your Honor, is the court going to do Xavier Garcia, who's before him?
If Xavier Garcia is before him, yes.
Yes, Mr. Garcia is here.
I don't have Xavier Garcia, so unfortunately, I think we're going to just have to pass that for now.
Okay, thank you, Your Honor. And this is Mr. Alvin Hazley.
All right, Mr. Alvin Hazley, sir, we have multiple cases as to, you have an active warrant for the first case, selling of cocaine and possession of paraphernalia, and bond will stay at $7,500 on count 1 and $500 on count 2. Similar charges on the second case, possession, sale of cocaine, count 1, bond will stay at $7,500. Possession of paraphernalia, bond will stay at $500. This is his last case.
He has 2 warrants before the court.
Yes, I'm looking at them now. It's just the paperwork. You also have a final case of 2 final cases, one of criminal conspiracy.
Your Honor, I apologize for interrupting, but that's Amari Hazley. This is Alvin Hazley.
Oh, okay, thank you. You're right. Got all these Hayes.
Your Honor, Officer Osborne would like to be heard.
Your Honor, will you be taking any action on his probation case that he's out on?
So there are some conditions of release as follows. The defendant is ordered to not return to the scene of the offense. As to his violation of probation, the court will order a violation of probation based on the new law violations, and bond will be set at no bond.
Your Honor, may defense have the case number?
The Osceola County case number is 21 CF 3027.
Thank you.
Also 22 CF 226.
Both cases are for BOP.
Yes, I'm showing he's on probation for both cases.
Thank you, ma'am. All right. This is recall paperwork. This is the case that's being recalled. Is that being recalled? Okay. Okay, please. All right, the next case is Amari Hazley.
President approaching, Your Honor. Your defense would like to be heard regarding the new charges.
Let me address the active warrant. Sir, you were picked up for, you had an active warrant, criminal conspiracy, a felony of the second degree. Bond will stay set at $7,500 as to that. You are ordered to not return to Key West Market as a condition of your release. As to the new law violation, the public defender may be heard.
Your Honor, defense would argue that regarding the cocaine, again, that alleged substance was not tested. And,
What says the state?
Yeah, there's no, well, he is part of the narcotics enforcement unit. I'm assuming that maybe he has training, but since we don't have that documentation that he's able to just recognize drugs, the state agrees that there is no testing or anything to verify the substance.
That also affects the court's ruling on count 5. Can the state provide additional information?
The state would be asking for a 24-hour reset to have the officer supplement the affidavit.
The court will grant that. The state is allowed 24 hours to provide additional information to supplement the probable cause. We'll reset this for in the morning. That's also Amari.
Thank you, Your Honor.
That's also Amari. And this is Amari. It's a bunch of Amari cases. Maritza Martel Cordero.
she requires a Spanish interpreter. Would the court like to address her now or at the end?
Now,
Ms. Cordero, por favor, véngase acá. President approaching, Your Honor. And Your Honor, defense believes there's mental health concerns, so defense would ask to be heard regarding release conditions.
we'll wait until the interpreter is available.
Thank you.
Madam Clerk, do you use the Cisco box or this box to get the interpreter?
Sobre los hechos del caso, okay?
Hello, Cisco Unity Connection Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions, press 4. Otherwise, please hold to leave a general message. Sorry, there is no operator available at this hour.
All right, let me just do a sound check. Osceola, can you hear me?
Yes, ma'am.
Madam Interpreter, can you hear me?
Yes, I do, Your Honor. Thank you.
All right. Madam Interpreter, this is Maritza Martel Cordero. Ms. Cordero, the court finds probable cause in your case for battery.
Muy buenas tardes, señora Maritza Martel Cordero, la jueza, ya que hay causas que respaldan la acusación de agresión.
The court is ordering a bond of $500.
La jueza está determinando que se le va a dar una fianza de $500.
Conditions of the bond are that you have no contact with the victim and that you not return to the location where this incident occurred and that you possess no firearms or weapons.
Señora, la jueza ha determinado que usted no puede tener contacto con la alegada víctima, no puede regresar al lugar de los hechos y no puede poseer ningún tipo de armas, armas mortales, armas de fuego.
Further, the court is ordering that you surrender any firearms or weapons in your possession to law enforcement within 24 hours of your release.
Una vez usted quede en libertad, tiene 24 horas para entregar a la policía, a las autoridades, cualquier tipo de arma mortal o armas que usted pueda tener en su posesión.
I have appointed the public defender to represent you in this case.
Se le designa a la Oficina de Defensores Públicos para que les represente en este caso.
Is there anything further from the public defender?
¿Alguna otra cosa de la Oficina de Defensores Públicos?
Yes, Your Honor, may defense be heard regarding release conditions for her?
Su señoría, ¿puede la defensa decir algo en cuanto a las condiciones de libertad para ella?
Yes, ma'am.
Sí, señora.
Your Honor, defense believes that Ms. Cordero has mental health issues.
La abogada de defensa piensa que la señora Cordero tiene unos problemas de salud mental.
In addition, very serious physical health conditions.
También unas condiciones de salud muy serias.
Therefore, defense would ask if the court would instead consider ROR on these charges or $100 instead of $500 bond.
Por lo tanto, la abogada de la defensa le está pidiendo a la juez que por favor considere permitirle salir bajo palabra sin tener que pagar una fianza o si no una fianza de tan solo $100.
What says the state?
¿Qué dice la fiscal?
The state has no objection to that.
La fiscal no objeta a esto.
Unfortunately, the court needs additional information to confirm the physical health conditions.
Your Honor, I can provide
This-
that to the court if the court would like.
Do you have it available right now?
I have Ms. Cordero's testimony. That's all I have.
That's not sufficient.
I understand, Your Honor.
All right, the court will deny the motion. Defense may,
Niega la petición presentada por la abogada.
defense may file a motion and is encouraged to include proof to support the defendant's concerns about physical health conditions.
La jueza ha denegado la petición de la defensa. El abogado de la defensa puede presentar una petición con pruebas que respalden la condición, el estado de salud de la señora.
Thank you.
Gracias.
Dwight, thank you, Madam Interpreter. I don't think we have any additional Osceola cases that need your services.
Okay, thank you, Your Honor.
Dwight Pinellas.
President approaching.
Mr. Pinellas, the court finds probable cause as follows for each of 4 counts. Count 1, resisting without violence. Bond will stay set at $500. Count 2, tampering with physical evidence. Bond will stay set at $2,500. Count 3, possession of marijuana less than 20 grams. The court will reduce the bond to $150. And count 4, possession of drug paraphernalia. The court will reduce the bond to $100.
And Your Honor, he also has a driving while license revoked, I believe.
You are correct. The court finds probable cause in that case as well. Bond does stay at $500 for that case. It's a separate case.
Will you be taking any action on the case that he's out on bond
No, ma'am, I wasn't aware of an out on bond case. If you can provide me additional information at this time, I'll evaluate it.
Okay, okay.
The case number, the charge,
Okay, the Osceola County case number is 22CF2089 for tampering with physical evidence, possession of cannabis less than 20 grams, and possession of drug paraphernalia.
no, the court does take no action on that case. And I do stand corrected, ma'am. I was provided with that information, so it was my fault.
That's okay, Your Honor.
Thank you.
No action. George Alberto Sinquias Simonetti.
Present and approaching.
Mr. Simonetti, you were picked up on a warrant for violation of your probation or community control. The court is ordering the bond to stay at no bond. Thank you, sir. Samuel Stradford.
Present and approaching.
Sir, you were picked up.
I apologize, but Mr. Stradiff would request the court to please waive the reading of the charges.
Yes, ma'am, that's granted. State, you don't have any objection to that, do you?
No, Your Honor.
All right, that is granted. The court does find probable cause for all charges and orders as to the violation of probation that bond stay set at no bond. Upon release, this defendant must be placed on GPS monitoring or electronic monitoring and report to the sheriff's office. This inmate does meet criteria for violent felony offender of special concern. Thank you.
Your Honor, Officer Osborne, pretrial release. I believe in order for him to be placed on GPS, he has to be under the pretrial release program, and he does not qualify for.
My order is that upon any release, the defendant is on no bond. That's just the terminology that needs to be included in the paperwork based upon the charges. The defendant is not released to pretrial. Does that clarify my order?
Yes, Your Honor, thank you.
Lawrence Anderson. State. The court does find probable cause as to both counts. The court is requesting the state's input as to the recommendation for bond as to count one, which is burglary armed of a vehicle. And as to count two, the court finds probable cause for theft of a firearm. What's the state's recommendation as to bond on count one?
I see that it has been reduced to none. We would just ask that it be within the bond schedule. It says there was no forced entry, so we would like the court to take that into consideration when setting the bond.
There's no corresponding bond schedule, specific entry in the bond schedule. Is this a third degree?
I'm checking right.
First degree?
I think it's first.
All right, then court will set, you're okay with me setting a bond?
Yes, Your
The
Honor.
court will set a bond of $20,000. And as to count two, the court will stay the bond at $1,000.
Thank you, Your
The
Honor.
court is ordering the defendant to have no contact with the victim, possess no weapons and no firearms, and surrender any weapons or firearms to law enforcement within 24 hours of release.
Your Honor, one moment. I believe that count one is a second-degree felony, not a first.
Yes, ma'am, go ahead.
May I double-check that?
Yes, ma'am?
Thank you.
Thank you, defense.
defense be heard?
Yes, ma'am.
Yes, defense believes that this is not a first degree. According to Florida statute 810.02, a burglary is a felony of the first degree if in the course of committing the offense, the offender becomes armed within the structure with explosives or a dangerous weapon. According to the facts of the four corners of this case, it's alleged that Mr. Anderson went into the vehicle, then took the firearm and threw it in a bush. He did not become armed prior to entering the alleged vehicle. So therefore, defense would argue that it's not a first degree and bond should be reduced.
Okay, I actually, I take your argument's well taken as to the reduction of the bond. But it is a first degree.
Yes, Your Honor, according to the.
And it will remain a first degree. At this, and I've already reduced it.
Okay.
So it actually technically should be much higher.
I understand, Your Honor. And defense stands corrected. I just realized that under paragraph 2, it says, if in the course of committing the offense, the person becomes armed, which is technically breaking into the car, taking the firearm. He became armed during the breaking, or I guess within the time of the breaking. So would the court consider lowering it from 20,000 to perhaps 10,000?
Actually, I've already lowered it, counsel. The court will not lower it any further. Technically, the court could order no bond. In this case, it is a first degree. It is punishable by life. The court has already reduced the bond significantly, so the bond will remain as the court has indicated.
Understood. Thank you, Your Honor. 20,000.
Did I do the no? There are additional conditions if I didn't order them. The court is also ordering that the defendant have no contact with the victim, possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of release, and not return to the location where this incident occurred.
And Your Honor, as to count 2, the grand theft of the firearm, $1,000 bond, correct?
Bond stays at 1,000. Yes, ma'am.
Thank you.
Damon Dolphin.
Mr. Dolphin is present and approaching, and he's requesting a waiving of the reading of the charges.
Yes, ma'am. The state has no objection to that.
No objection.
All right, the court finds probable cause on all charges. Bond will stay set at no bond. And as to the violation of probation, community control, bond will stay set at no bond.
Thank you, Your Honor.
Xavier Garcia.
Present and approaching, Your Honor.
Was I missing some paperwork on Xavier Garcia? The new law. Is there a new law? Just a violation? You don't have another?
Mr. Garcia is also waiving a reading of the charges.
Yes, ma'am. Mr. Garcia, you were picked up on view violation of community control. Bond will stay set at no bond in that case. And you are a designated violent felony offender of special concern. Also, upon any release, I'm not releasing you in this case, you are subject to electronic monitoring or GPS monitoring and reporting to the sheriff, and you're required to report to the sheriff's office if you're released in this case. All right. There you go. Recalling George Louis Adams or Adams.
Present and approaching, and also, Your Honor, he requested a waiver of the reading of the charges.
Yes, ma'am. State, you have
No objection from the state.
All right, the court does find probable cause in Mr. Adams's case for count 1 and count 2. Bond will be set at $500 on count 1, $2,500 on count 2. The court's ordering no contact with the victim.
Excuse me, Your Honor, there is a victim here present.
Oh, actually, there's a victim from Osceola County that's present, So we're going to, do you speak English? All right, we're going to swear her in.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
State your name. Ashley Cullum.
All right, Ms. Pullum, we're going to have some questions that are asked by the prosecutor and/or the defense counsel. We do need you to answer the questions into the microphone so everybody can hear your responses, okay?
Yes.
All right, thank you.
Good morning. What's your relationship to the alleged defendant?
He is the father of my child.
Okay. Are you seeking contact with him today?
No.
Are you afraid of him?
No.
Okay. No further questions at this time, Your Honor.
Does the defense counsel have any questions?
One second, Your Honor. No, Your Honor, not at this time.
All right, the court is ordering a bond on count 1 of $500 and count 2, $2,500. The court is ordering no contact with the victim, no return to the location where this incident occurred, maintain separate residence from the victim. The court is authorizing a one-time visit in the presence of law enforcement to retrieve personal belongings or effects. Any questions, ma'am?
No.
Thank you, ma'am. You're excused.
Your Honor, one moment to confer with Mr. Adams regarding the bond.
All right, ma'am, can you just wait 1 moment?
I'm sorry, Your Honor.
Anything further from the defense attorney?
I'm sorry, Your Honor.
I gave you 1 moment to confer. Now that you have conferred, do you have anything further?
No, Your Honor. Thank you.
All right, thank you, ma'am. You're excused. Thank you, sir. You can have your seat.
Thank you.
All right, who was that other recall? So,
You just did it, Your Honor.
oh, it was that one? All right. Any other matters from Osceola County before we disconnect?
No, Your Honor. At what time would the court like to begin tomorrow?
Same time as today.
11:30?
As close to 11 o'clock as possible, ma'am. 11 o'clock. I mean, just because I didn't